this body to understand title, land on Mauna Kea, and even go so far as the metes and bounds of the so-called state of Hawaii. He is a professor of law at the University of Hawaii Law School, where he has been practicing for 34 years. And he's even written books on this matter. And so I think it's very, very important that this relativity be presented.
How is it relevant to the issues that are before us?
Much to your disagreement, land transactions, anything to do with land, especially when it's my land, should be discussed.
Is that all that Professor Chang has been called to testify about?
When you say all, can you clarify that?
Well, I'm accepting your offer of proof based on
Yes.
what you just said. Is that everything? Because it doesn't sound like it's material to this hearing. We've had many discussions about this. I have an order out.
We're going to get into a shooting match here because you have your order out that you agreed with some of the parties, but not with all of us. Okay? Now let's go by the rules. I'm going by the rules. Believe me, I have read them 1,000 times just for this reason. And quite frankly, you're telling me that we cannot bring fundamental factors of law into this case is not correct. It is very much relative to this case. It has to do with the leasing of land that do not belong to the University of Hawaii or the state of Hawaii. They actually belong to me, and I want somebody to be able to show how, in fact, it is. That's why I brought this witness. Like I said, he's a professor of law at the University of Hawaii. He's been teaching this subject for 34 years.
Mr. Shinyama, did you stand to address us?
Yes, Your Honor. We would object to the offer of proof. The testimony of Professor Chang is immaterial and irrelevant to this proceedings. Basically, we're going back into illegal annexations and the overthrow of Kingdom of Hawaii and the ownership of title to this land. All of these issues have been ruled upon by either the board or yourself in minute orders 14, 17, 25, and 29. This information, the testimony all attempts to argue political issues for which neither the board or yourself have jurisdiction over. Finally, and this is just to wrap everything up, Your Honor, in minute order 19, which was your order, you specifically ruled that issues related to sovereignty of the kingdom or existence of the kingdom, challenges to the legal status of the state of Hawaii, and challenges to the state's ownership of and title to lands will not be addressed in this contested case hearing. So for all those reasons, Your Honor, we would object to the offer of proof and to Professor Chang testifying in this proceeding.
Mr. Sinkin?
Thank you, Your Honor. I actually prepared a statement in case this arose. In minute order 19, the hearing officer ruled that the following issues would not be allowed. First, the sovereignty of the Kingdom of Hawaii or any other issues relating to the purported existence of the Kingdom of Hawaii. Second, challenges to the legal status of the state of Hawaii. And third, challenges to the state's ownership and title to the lands related to this contested case hearing. That ruling by the hearing officer relied primarily on prior court rulings regarding the continued existence of the kingdom and the legitimacy of the state of Hawaii government. The temple has consistently argued that due process requires the temple and other interveners be given the opportunity to develop a record supporting the proposition that the state of Hawaii does not own the lands where the 30-meter telescope is proposed to be built. The temple challenged the hearing officer's prohibition on raising that issue in document 293, the temple's motion for reconsideration. In that motion, the temple argued that the law is a living entity and changes over time. Issues decided by the United States Supreme Court have been overturned later. The temple also argued that those who sought to change the law should be given the opportunity to create a record which an appellate court could rely upon to change prior rulings. The basis for arguing in favor of a change in the law would be that new facts and arguments have emerged that were never previously considered by the judicial or executive branch. Those facts and arguments can only be placed in the record if those who intend to argue for a change in the law are given an opportunity to create that record. Professor Williamson Chang has now brought just such argument and evidence to this proceeding. I have only two questions for Professor Chang. To the best of your knowledge, has any federal or state court ever directly addressed the arguments you make in your pre-filed testimony here today that the annexation by joint resolution was legally ineffective? And the second question I have for him is, in your opinion as a professor of law, if the annexation was found to be illegal, would any of the laws by which the United States dispossessed the kingdom of its lands be legal? The Temple urges the hearing officer to reverse the earlier ruling in Minute Order 19 and allow those who wish to develop a record on the kingdom's continuing ownership of the lands at issue in this proceeding to present their arguments and evidence.
Thank you, Mr. Sinkin. Ms. Pishora?
Aloha. I wanted to say a couple of things. I believe his testimony is relevant. And why is because his testimony addresses the legality of the CDUP, or CDUA, I'm sorry, Conservation District Use application. Because on the Conservation District Use application, the landowner is identified as the state. Now, that's an okay answer if you're not actually trying to be accurate. If you're trying to be accurate, then you have to identify that the landowner is the state insofar as they are the trustee as established under the Missions Act. I think it's that simple. When you're talking about the disposition of land, you have to identify who it is that is claiming the ownership and where it's going. For the same purposes, we disagree with the fact that the TMT or the TIO or whoever they want to call upon are not actually even on the application as well, that it then goes directly to the university as the applicant. So I believe his testimony is relevant because it establishes or dismisses the inaccuracies or will challenge the accuracies of the CDUA itself. So those are my major objections. I do believe that things relating to our history and the admission of Hawaii into the Union should specifically be allowed and spoken to, and I don't see an injury in it because it's less about the kingdom question and more about the title question. So everyone knows that we have to establish title if we're going to try to transfer land, and in this case it's give our sacred land to someone else to use in a way that is not in keeping with the sanctity of Mauna Kea. Mahalo.
Thank you. Mr. Ching?
Your Honor, I believe that the issue is on the table. The applicant has the burden of proof of this tribunal's jurisdiction. I believe that what Professor Chang may be offering is material and relevant to this case, and I would join Mr. Simpkin and Ms. Kiloa in their arguments. Thank you.
Thank you, Mr. Ching. Ms. Kihoi?
Aloha, Mehana Kihoi. I believe that what Professor Chang has to offer is relevant. He represented individuals who were arrested on the mountain and represented them in court. And I believe that he understands the emotional and psychological injury that could result following the number 8 criteria.
He's not being offered for that.
Okay, well, I just wanted to add that. I wasn't sure what the full offer of proof was, but I just wanted to add that.
Thank you.
Thank you.
Ms. Freitas?
Yes, I concur with Lenny and Prosciutto on the issue about putting Williamson Chang as for testifying. He is part of the key, and we need to ask him some questions. And I think it's in our due process of our rights to ask him some of those questions in his opinion. Thank you.
Thank you. Mr. Freitas?
Aloha. I too agree that Mr. Chang should have his testimony cross-examined. Personally, because my issue too is Article 12, Section 7, which he states in his WDT, and I would like to have the chance to cross-examine him on that issue and other things that are part of his WDT. So I plead that the hearings officer will allow him to testify.
Is there anyone else? I'm sorry, Mr. Vicente, go ahead.
Dwayne Vicente. We're playing with 3 different jurisdictions: Hawaiian Kingdom, United States Constitution, and the third wheel, the Northwest Ordinance of 1787. I believe this proceeding is based on the Northwest Ordinance, and that's why he should testify to that fact. Thank you.
Mr. Louis Kwan?
Your Honor, we would join in TIO's objection to the materiality of Professor Chang's testimony. Again, we believe that the Land Board and this hearing officer has already ruled on materiality. And again, we still believe that both this proceeding as well as the Land Board and the courts are without the authority to make a declaration that the overthrow of Queen Liliuokalani and the annexation of Hawaii was illegal. That's not going to change anything.
Mr. Flores?
Aloha, and E. Kalani Flores, representing the Flores case, Ohana. I concur with Ms. Gota and Lenny Sinclair in regards to what they said, but in particular, I don't believe his entire. Mr. Chang has an extensive witness testimony, I think over 20 pages, but I don't think all of it is inclusive of what is being argued or objected to.
It's 34 pages.
Yeah, okay, exactly. And I believe that it is relevant to the 8 criteria, and that particularly whether this proposed land use is consistent with the purpose of the conservation district, and which is number 1, and as well as based upon my reading of it. Number 7, regarding subdivision of the lands. Thank you.
Anything else, Mr. Fergerstrom?
I'd like to state again for the record that this written direct testimony has been available online since October 11th. Had anybody had anything to say like this before, they could have raised it. They failed to do so. The state of Hawaii is asserting that they are the owner and have title to the lands of Mauna Kea, and they have offered no such proof. I have a person who will give a testimony that challenges that position, and if they had anything, it would be under trust lands anyway, and then you'd have to deal with trust obligations. And I think Mr. Chang is more than qualified to speak on all 3 levels of that thinking. And so I do again offer him as a witness in this case.
I'm not going to accept Professor Chang as a witness in the case.
Okay. Then I want you to give me.
I will allow. The reasons are already stated for the record many times. I have been consistent in my rulings on this issue as they've been
You've been consistently wrong.
Excuse me. As they have attempted to be brought up quite often.
Yeah.
I will allow you to introduce the written direct testimony as an exhibit that would evidence your offer of proof. It's 34 pages, it's very extensive. It would make for the record what it is you intend to offer and what it is I am rejecting.
So, can you clarify that a little better, what you just said, that you will allow?
I'm allowing you to submit the written direct testimony as an exhibit in support of your offer of proof. So I'm not going to consider it as evidence in the case, but because I would like you to have a record of what Professor Chang would be testifying about, I'm going to allow you to bring it in as an exhibit. Do you understand?
I sort of do. Does that say that you're not going to allow him to testify?
He will not testify.
Okay, then I'm going to hit you with a bill because you had prior knowledge that I was going to bring him up. You knew I was on Social Security, and what did you say to me? We all have that same problem. I'm going to bring it back to your door. Thank you very much. And you will be hearing lots about it. If you think this is the last word, you're nuts.